I'll be right back.
Mhm. Well, just checking people in here by getting their screen names adjusted when necessary to affect their party affiliations. I'm just going to leave the individuals as they've used using their names that they present here, unless I need to just clarify it. But takes a few minutes, get all that sorted. So I was just curious, have Ryan Hunt in the waiting room? Is that someone people recognize, possibly from the applicant?
Your Honor, did you say Ryan Hunt?
Yes, that's right.
I know there's a Amy Jo Hunt who is an intervener,
Ah,
so
yes. Okay, I
that
see.
may be the relation there.
Got it. Yep, you're right. Thanks. I've been calling them 435, so I'll just put that in front of the screen name. Fourth, 35.
It's going to be a good day. There's two red cardinals. I mean, two male cardinals on the bird feeder.
Oh, they're getting along.
Yeah,
Take their lead with that.
it looks like they're staring at me. They can't see me, but I can see them.
How about Barbara Brown? Anyone recognize Barbara? And let her in and see what's going on there.
Hello.
Good morning. Hear you.
Good morning.
Good morning.
Good morning. Was that George?
That was George. Sportsman.
No, familiar last name.
Yes, I was a CHC intervener also, Judge.
Yes, yes. About Deb Dawson. I don't see that person on our list. Recognize her? Come in and see. They're just using a different screen name. Yeah, well, before we get started, I just wanted to check in with Barbara Brown, or maybe you're a different person underneath your screen name.
Barbara Brown is one of our members, Your Honor.
Oh, okay, great. Thanks. Perfect. All right, I'll just add you that. Yeah, I did not check that closely. Like, thanks for letting me know. Oops.
Are we stating appearances or can you see us?
I can see you. Right now, I'm just checking screen names, making sure we got everyone in the Zoom. We'll do appearances once we get on the record. So I think Deb Dawson, is that a person with WPM as well?
Your Honor, Deb Dawson is with Michael Best. I think it probably would be better if she just joined the YouTube.
Okay, well, I'll leave that up to her.
Sure.
What you got to remind me, what party are you with now?
Renew.
I gotta go in circles here.
Yep.
Oh, great. Yeah, thanks for changing your name there. So I'll add Renew to her designation, that person's designation, and then that's okay. I mean, if you're affiliated with a party, you can be on the Zoom. It's just if you're public.
Sure.
Okay, so Randy Statterfield, that's not a name I recognize here. Anyone know that one? I'll let them in and figure that out then. So Randy Statterfield, I see you've connected to the Zoom hearing for Badger Hollow Wind Farm. Just curious if you're connected with a party in any way? One of the interveners? I'm going to unmute you. Randy, can you hear me?
I can hear you.
Okay, great. So the pre-hearing conferences, the Zoom connection for the pre-hearing conferences for parties and interveners, people requesting intervention. I don't recognize your name.
Oh, no.
No.
Okay.
Yeah. So I can direct you to the YouTube live stream if you'd like.
Okay.
To,
Great. I'll find that. Thank you.
Got that? All right. All right. No problems. Thanks.
Sorry about that, Matt. Had to.
Like we're slowing down with people joining us. About 3 minutes overtime, so not seeing anyone else joining us. I guess I should mention at this point before we get started, the notice of pre-hearing conference. It's on the screen share, and you know, because we're not actually seeing all the interveners connected, I did want to emphasize the well, what I have here in the table up with parties as proposed interveners, 1 through 14. I've not issued a order accepting the intervention, so I'm calling you proposed interveners. And then on page 3 of the notice, this end of the first paragraph, it does order that any proposed interveners who fails to appear will be deemed to have withdrawn their request to intervene. So not seeing everyone up here. I just wanted to mention that we will be here for a while. So if someone did not catch that for some reason, I'll give you a chance to join. But yeah, I'm going to hold people to that. We have a lot of interveners here, and people may not have had understood what the rights and responsibilities are until I sent that letter out. A letter to interveners explaining that, and maybe they've changed their mind. So that's the process by which I can allow proposed interveners to make that choice by appearing here or not. So, and it could be their designated representative. So as we mentioned above there. So let's get started. I think, oh, there we go. Now they're coming in. Cooper Johnson, anyone recognize Cooper?
He's with us, Your Honor,
I
applicant.
thought so. Yeah, okay. Did recognize that name. Like our live stream is up and running, so we should be good to go. All right, well, let's get started. Let's get on the record. Welcome, everyone. This is Docket 2827 CE 100, the application of Badger Hollow Wind Farm for their CPCN to construct, wind generating facility. My name is Michael Newmark, the Administrative Law Judge for the PSC. We are on Zoom with the party, which right now is the applicant, and proposed interveners, the people, individuals, and organizations that have requested intervention in the process. As we issued the notice of pre-hearing conference, and it's the standard process for this. We'll be looking at who the parties will be, issues, scheduling, and any other facilitating matters. We'll take appearances first. We want to do that on the record. So we'll go take our list of the current service list and check people in. I'm going to put that on the screen share. And let's begin. Applicant on the top doesn't happen all the time. So that's interesting in this case. So let's see.
Yes.
I'm sorry.
Yes, Richard Jenkins.
No, it's not your turn yet. I'm sorry.
Oh, okay. Sorry.
So what we'll be doing, Richard Jenkins is, my understanding is you're represented by Frank Jablonski, who's counsel for representing you as an attorney. I'm going to be expecting that he will be speaking in the pre-hearing conference. I won't expect you to be chiming in on this. If you need to consult Attorney Jablonski, I don't know if you're in the same room or what you need to do to communicate, but it becomes necessary when we have a question that's can't be answered and we need you to chime in. I'll let you know, but I'm going to mute you now and I'm going to have your attorney speak on your behalf during the pre-hearing conference. Is that understood?
Thank you. Sorry.
Oh, great. No worries. All right. So let's start with Badger Health. Who's representing them?
Good morning, Your Honor. Jess Polakowski appearing on behalf of Badger Hollow Wind Farm, LLC.
Perfect. Clean Wisconsin.
Good morning, Your Honor. Katie Nicola representing Clean Wisconsin.
Okay. Rob Danielson.
Good morning, Your Honor. Representing myself.
All right. Welcome back. Linda Grace.
Good morning, Your Honor. I'm representing myself and Grace Family Farms, Wisconsin, LLC.
All right, thanks. The Jenkins.
Progressive Law Group, Frank Jablonski, representing the Jenkins.
Thank you. Klopp, Chris Klopp. Saw you there before. There you go.
Hi, Chris Klopp, representing myself.
Okay, Dina Kurt. No, not seeing Kurt. All right. I'm going to pronounce your name wrong. Is it Metalicia?
Let's see, Gina Metallica, representing myself.
Okay. Were you in another case before?
No, I haven't.
No, okay. Your name sounds familiar somehow. Morris, Peter Morris.
Yes, I'm here representing myself, Your Honor.
All right, thanks. Mary Owen. Didn't see you on the list yet. Okay. All right, Public Service Commission.
Evan White's on behalf of the Public Service Commission of Wisconsin. Also appearing this morning is Stephanie Bedford. Good morning, all.
All right, thanks. And I don't have you on the list, do I? Add you to that. Okay.
Doesn't look like it. So we can make that revision, please.
Yeah. Got it. All right, Larry Regan.
Yeah, hi, I'm Larry Reagan, and I am representing myself, Your Honor.
All right, perfect. Thanks. So just a note for you that your audio is a little choppy. So going forward, you might want to look into, I don't know what might be causing that. It could be your wireless connection or your internet, but there's something you can do to check into that. It would be useful for all of us.
Yeah, I'm not getting a real good signal today.
Okay, well, so when we do have the hearing, it's going to be a long day or more. We'll be talking about that, and you probably want to have a robust signal for that time. So I would plan ahead for it. Renew Wisconsin.
Morning, Your Honor. Ori Walsvik, Michael Besson Friedrich on behalf of Renew Wisconsin.
All right. George Schwartzman.
George Schwartzman, representing myself, Your Honor.
Okay. So I'm calling the trustees of 435 County Highway E, but I think we have Amy Jo Hunt. No, or is it Ryan Hunt? Ryan Hunt's the screen name I have in front of us.
Good morning, Your Honor. It's Amy Jo Hunt. The Ryan Hunt, the screen name is my husband's account.
Got it. Okay.
And then we also have.
Good morning, James Biddick. James Biddick, representing trustee for 435 County Highway E.
Yeah, okay, I see you there. Okay, great. So I'm going to change that your name there just to, we can go off the record for this. Adjust your name on the screen. Does help our court reporter to keep track of who's speaking. It's one of the more important things we need to do here. All right, so Wisconsin, let's get on the record now. Wisconsin Policy Monitor, LLC.
Thank you, Your Honor. Eric Olson of Eminent Domain Services, representing Wisconsin Policy Monitor, LLC.
Great, okay, welcome. So I think that's all of the interveners. I think it's the end of my list. So hopefully we've got everyone. Oh,
Judge, I just wanted to point out, it looks like I'm not on the service list.
All right.
And neither is Jordan Hermiden, who entered an appearance. So if we could add, I'd appreciate it.
Yeah, okay, I think you're on the, maybe that's another case. Okay, yeah, I'll do that. Yeah, thanks. So it's you and Jordan. All right. Okay, so I wanted to just let's stick on the record here. I did want to mention the importance of this list, and it looks like so you don't usually get a copy of this, but I wanted to make sure everyone received the notice of pre-hearing conference by email. Did we miss anyone? So the reason I'm asking is that we serve that to you using the emails that we have on file, and that's represented by the list here. So if we have the wrong email or we typed in wrong, you're not going to be getting our communication. So I just want to make sure if there's any mistake here, that we get the right email entered. If I remember, I can send everyone a copy of this list. I just don't usually do that. So I'm going to make a note, and if you get the email, then you're probably okay, but. Okay, so let's get started or restart the next phase of this. Oh, and let me mention, so I'm not seeing, we don't have an appearing today. Kurt, is that Dina M. Kurt, nor Mary Owen, MD. They did not appear so far. So
Your Honor, I could add something to that. So I know that Dina Kurt told me that she was not going to intervene and she was going to put something in on the docket. Apparently she did not. So I'm not speaking for her, but I'm just letting you know that. And the other thing is Mary Owen is a physician and she's sometimes very busy. I texted her just to remind her. Maybe she'll show up here at some point. I get that you know, it'll matter if she shows up, but I'm just saying that I'm hoping, I don't know any reason why she wouldn't show up unless she, you know, just got busy or I don't know. But anyway, so.
Okay, I understand. Thanks, I'll note that. I mean, as of now, I'm going to reject their intervention. If they do appear by the time we adjourn, we can discuss changing that. But in case I forget, by the time we're done, we'll reject them at this point. So let's continue on. So there was some other logistical matters here in terms of choosing our parties. So for the people who did appear and there's no objections to their intervention, I can accept you as parties. So there are 5 interveners that where the applicant has opposed the plan. So I think I did want to maybe take, one of them is Dina Kurt, so that's already been decided or covered here. I think with a Wisconsin Policy Monitor, I know that WPM has complied with my request to file additional information. Well, based on that, I mean, I think they've cured what the applicant has been the objection the applicant raised. But I guess I should let the applicant just confirm if that's the case, or if they have anything else they wanted to add on WPM's intervention.
Thank you, Your Honor. Based on the supplemental briefing, we will withdraw our objection.
All right, great. So we'll include WPM on the parties list. So let's move on to the other opposed interventions, and I did conveniently, for my convenience, list them here on the notice of a notice pre-hearing conference. So we have the Rob Danielson, Chris Klopp, Dina M. Kurt, which we will now. Well, let's just include her in case something happens in the meantime. Peter Morris. Those 4 interventions are now currently being opposed. We did get. Yeah, so they were opposed by the response and opposition filed by the applicant, 2 of those. And so at this point, I can give the interveners who have been challenged the opportunity to respond to the applicant's response. So why don't we start off as close to alphabetical as we can here. So I was listing them by last name. So why don't we start with Rob Danielson? Did you have anything you'd like to say about the applicant's objection?
Not that I haven't included in my written response, Your Honor.
Okay, let's go off the record then. I don't think I saw those written responses. Okay, let's see if we have, let me check those out. So we're off the record. I may just have you reiterate some of that, but let me just check and make sure I didn't see that response. So I apologize for that. Okay, is there any, do you know what file type you might have used? Was it in request to intervene?
I can go online and find the BSC ref number. Okay.
That's good. I'll just search using your name here. Oh, there you go. Huh. November 27th. Wow. I did not see that.
27th of December.
Yeah. Yeah. Oh, I have that here. Okay, so I think looking at your response, I think let's try this. I think maybe the most, because I need to review all of these now, but let me review Peter Morris's. There you go. Everything. Response. So I'm seeing, in terms of responses to the objections, I've just reviewed responses from Rob Danielson, Peter Morris, and Chris Klopp. Were there any others? That's all we have, right? Okay. All right, so let me turn this around then. Does the applicant have any response to these filings?
Are you still off?
Yeah, no, let's get on. Yeah.
Okay.
Yeah, so any response from the applicants on the three responses from our interveners?
Yes, Your Honor, I'd be happy to address them individually if you'd prefer, or I can just give some generalized comments that I think are applicable to all three.
Why don't we start with the right to intervene?
Sure. So, Your Honor, we do not believe that that these three proposed interveners satisfy the standard for intervention of right. Intervention as of right is governed by PSC 2.21 parent 1, and it requires that a proposed intervener show a substantial interest that may be affected by the Commission's decision. This is the same standard as set forth in 227.53, and so case law on that statute and interpreting standing for the purpose of this inquiry is relevant. Substantial interest has been interpreted to require both a direct injury and an injury which the law seeks to protect. Here we have proposed interveners, I should say, who state generalized concerns that are the same as any member of the public would have or may have. There's nothing unique or particular about their situation. There's nothing unique to them that would be experienced by them, that would not be experienced by any resident of the state of Wisconsin writ large. Case law is clear that that is not enough to satisfy standing and is not a substantial interest under Wisconsin law.
Okay. Yeah, so I've reviewed the intervention requests and heard the arguments on both sides. I think I will agree with the applicants in terms of a right to intervene. None of the challenged applicants, challenged interveners have demonstrated a right to intervene, a substantial interest. There may be some argument about how far away from the project you need to be. That's going to be a subjective standard. But when it comes to being miles away, that definitely raises scrutiny, increases scrutiny as to substantial interest. And I don't believe, from what I've seen from the filings and the chances to respond that we've provided, that the interveners have met that burden. So in terms of substantial interests, I'm going to reject the.
Your Honor, do we get to say anything here? Because
no, I've already read your response, so we've provided.
I realize that, but there is one item in my response that I don't believe is covered by what you're discussing. Can I speak to that, or?
Go ahead. Point to me in your response.
It's probably in the beginning. Well, let me just see. Yes, it would be starting on page 2. So 3 public utilities, one of which is Madison Gas and Electric.
Right. And so you're talking about the cost?
Yeah, the thing is that every single docket.
I'm sorry. Stop.
Approved.
Stop.
For that. So why wouldn't that not be
stop? All right, I'm going to mute you if you won't stop.
Okay.
Cost is not an issue in this case, and we're not going to be bringing it up, and we'll talk about that in the issues list, but you can't have a substantial interest involving the cost of this project. So we're not going there, and I'm rejecting that argument. So you have no substantial interest based on any utility rate impacts. Okay, so substantial interest, I don't see that occurring in these interveners. So in terms of intervention, permissive intervention, like we say, the ability to promote the investigation, looking at the interests, the issues in the case. Does the applicant have any response to these, to the interveners' filings on that point?
Yes, Your Honor, thank you. It's our position that these 3 proposed interveners also fail to satisfy the criteria for permissive intervention. Permissive intervention requires that their participation would promote the proper disposition of the issues and would not impede the timely completion of the proceeding. The issues that are raised in the responses to our objections to intervene are largely irrelevant or duplicative of issues that are already raised and addressed in these proceedings and will be addressed at length in these proceedings. So it's our position that any of the arguments offered in the responses to our objection to the motions to intervene with regard to the standard for permissive intervention don't satisfy that standard because they are likely to be duplicative, will result in delay, and are irrelevant, as Your Honor just noted, for instance, with regard to cost of these proceedings. Cost was raised in detail in the Koshkonong proceedings where these interveners were parties to the proceedings. There were discovery disputes related to that. Your Honor had to decide motions to compel, which were decided in applicant's favor. It's our position that that is a waste of your resources, of applicants' resources, and of the public's resources at large. So we would ask that permissive intervention not be granted for the reason that intervention of these 3 proposed interveners would be duplicative of the issues that have already been raised. I would also just note that other interveners in these proceedings have raised all of the issues that are addressed in the responses to our objections. These proposed interveners can certainly participate by public comment to the extent that Mr. Danielson has information that he would like to present with regard to his experience. He could participate as an expert witness on behalf of one of the interveners, but I do not believe that qualifies him to be an intervener, either as of right or permissively.
Okay. All right. So that is an interesting offer and suggestion that the for to the extent that any of these proposed interveners have expertise to bear on the case, that they may participate as a witness on behalf of a party that we've already admitted to the case. I guess I'm kind of curious, Attorney Polankowski, in terms of it being duplicative, I think what we're focused on is what I have on the screen here is Rob Danielson's experience in sound and audio work, which of course will be a contentious point in a wind farm case, as some of us here have experience with. You mentioned that the permissive intervention may result in duplicative evidence, and I was wondering, to what extent do you anticipate Rob Danielson's experience on sound to be what you were talking about? Is that something you were referencing in your mind, or can you give a little more detail on that point?
Your Honor, Mr. Danielson is a professor of film. We do not believe that his expertise is relevant to the field of sound in wind turbine technology. So I don't believe that he has relevant expertise. I was just suggesting, to the extent that he believes he does, he could either participate via public comment or perhaps as an expert witness if he were so qualified. I anticipate I would object to that for a number of reasons, but that is an avenue.
Okay. Yeah. Okay. So I think that is a potential compromise. But I think in terms of we don't really know, and we don't really need to get into the details about Mr. Danielson's expertise here, but it's not that it would I just want to make sure your understanding was it wasn't necessarily resulting in duplicative testimony, but you may have issues with relevance, which is or the competence of the witness, which is something that could be dealt with when we need to deal with it.
I do believe, Your Honor, that other interveners have raised the issue of noise concerns. So to the extent that he's raising an issue with regard to noise associated with the project, that would be duplicative.
It's not a novel issue for this case, but it is one that's relevant to the case. Okay. And any response to Mr. Morris's permissive intervention claim?
Likewise, with regard to Mr. Morris, I can go through each of the concerns that he raises if you'd like. As you noted, his property is 17 miles from the project area. He raises general concerns regarding wildlife. That does not, that first of all, there's other interveners who have raised that concern that will be addressed in detail in the proceedings. He raises concerns as a ratepayer with regard to cost. That's not relevant to this proceeding. He raises concerns with regard to the school district. The school district has submitted a comment and has opted not to participate in this proceeding. He's not in any way representing the school district. Again, cost is not relevant. To the extent that there might be safety concerns, those are addressed in detail in this proceedings as well. So generally speaking, the concerns that he raises are all addressed by other interveners. He raises generalized knowledge that he has about other wind projects. I don't believe that those are relevant to this project, particularly with regard to projects in other states and experience with the applicant in other states. He offers irrelevant and speculative information with regard to Invenergy's business practices. Again, that would not aid in the disposition of any issue in this proceeding and would result in delay. We believe the issues generally raised are duplicative and or irrelevant to the proceedings, and thus his participation would result in delay and would hinder these proceedings.
Okay, so I tend to agree with the applicant on all three requests, and I'm going to deny those requests. I think the issues raised are issues that will be in this case so that there's no unique or novel concern or special expertise that's being presented as far as the intervention process goes, and or as far as we could glean from the intervention process. And to the extent that these people as individuals have expertise and experience they wish to bring to bear in this case, they would it's best that they do so through a party who has a substantial interest in the proceeding. I think that the record is best served when people with substantial interests are allowed really the time and resources and frankly my attention to be put to their participation, and that the record is best served when people with substantial interests are the ones that are involved and can lead the case and present issues on their concerns. So those concerns that have been raised by these contested potential interveners are also been raised by current interveners, ones that we have accepted. So the issues will be covered to the extent that those interveners wish to engage with these particular individuals. They may do so, and to the extent that the evidence gets presented, sponsored by those parties through these witnesses, we can deal with evidentiary issues as they arise. But I think that the record's best served if we have people with substantial interests and people who we can clearly, without a doubt, accept as parties, intervene, and so long as we have no missing concerns, there's no missing coverage with the issues being raised, to the extent that they're relevant issues, I think we will have a good process here and a complete and accurate record. So if that's the case, we have switching back to our notice here, I'll be rejecting the interventions of Rob Danielson, Chris Klopp. So far, Dina M. Kurt, we didn't actually get a response, so she's both has not appeared and did not file that response. So I think we can clearly reject that intervention, as well as the intervention request from Peter J. Morris. And I did want to mention I did see Mary Jo Owen Oyen did join us, so I'm going to ask you to unmute and turn on your screen. Mary Jo, can you hear me? I'm going to unmute you. I can't turn your screen on, but I can unmute you.
Okay, I think I've unmuted.
Yes. Okay. Can you get your screen on?
Not sure. I just got a new phone, so I'm struggling with it.
Okay. I just sent you a request. You probably saw it pop up.
There we go.
Okay, great. Okay.
All right.
So, yes, thanks for joining us. So like I did mention at the beginning, and as noted in the notice of pre-hearing conference, you did need to appear today to maintain your claim to intervention. So I appreciate you joining us. And there were no objections to your intervention, so I can accept you as a party. I know you're on your phone right now. Just so you know, I mean, we'll be here for the party session. Will take a long time. Just make sure you have the equipment you need to be able to participate and witness the hearing over a long period of time. So I want to mention that. Otherwise, we're going to move on to, I think there was one other person that had joined us.
Your Honor, I would like an opportunity to respond to one item in my response to counsel that was not addressed.
All right, go ahead.
Yeah, first of all, there was no mention of cost in my response, as council mentioned, but the item of the potential conflict of interest with the Wingville town clerk has not been addressed, and that is not addressed anywhere else in any of the interveners. So this would be a unique, as a Grant County resident, unique to my request to intervene at the on the last page. And council did not address that.
I think that was mentioned as something irrelevant, they had called it, which is debatable. I'm not making a ruling on that. But I think what I was my decision still stands in terms of saying, well, we can, if a existing party, a current intervener wants to present that evidence, they can engage you in order to do that. But in terms of having you do it on your own as a party, want to keep the case, as straightforward and simple as we can. So, and it's going to benefit everyone to make sure that people who are I'm going to mute you, Mary Jo.
3rd Street.
So, it's beneficial to the record to keep, to have people with a substantial interest present these arguments. So if they want to engage you and get information from you or sponsor you, that's one thing we can do. But in terms of having you present this on your own as an intervener, I don't think that's going to be beneficial to us.
I understand that. I did have a question as to why certain interveners, proposed interveners, are being excluded based on their proximity when there are other interveners who are of equal or greater distance from my location.
I didn't think that was true.
May I ask a question, Your Honor, in relation to this? My question is why Clean Wisconsin and Renew Wisconsin are being included as interveners? What is their substantial interest?
I didn't say they had a substantial interest. I said that no one objected, first of all.
Oh, so I cannot object as an intervener then to their inclusion in the list.
Well, I think that's really beside the point at this point. I think what Clean Wisconsin and Renew have expertise that has benefited the commission for decades in many cases on multiple topics, construction cases, rate cases. They bring to bear expert witnesses, and we're talking about experts with published scientific articles, people who are doing research in different fields in the environment and renewable energy, the electric grid, energy planning, all of the information that they bring to bear over the course of, well, I think for Clean Wisconsin, it's been probably 50 years. Renew, it's been since 1990s. They've intervened in countless cases and challenged us many times as well. I mean, they've both added substantially to the record in many cases and also challenged our decisions. So they definitely are involved in our process, probably to almost the greatest extent of any intervener, and they benefit the record. So in terms of if I needed to make a decision, which I'm not going to do, they at least meet the standard of permissive intervention because of their contributions in the past and what I expect to see from them in this case and going forward into the future. So I believe, I don't want to get into this too deeply, but their requests usually do cite that they're members in the area. I don't know if they did in this case. If there's members in the project area, then obviously they're representing those members, and the law recognizes them, therefore, as having a substantial interest. If
Your
they
Honor.
hang on. If they didn't state that, then at least they have permissive intervention. So that's just in ways of explaining that to you. I don't really need to make that ruling because no one objected.
Thank you, Your Honor.
Okay, so before we move forward, I just wanted to check in with someone who had joined us, but I don't see them anymore. Okay, all right. So I don't know if I've covered everything I need to cover at this point. I know
Can
Linden.
I ask a question before I go on to the YouTube part?
No, you're not a party. So I'm actually gonna.
I just wanted to ask a question about the transcript, that's all, of this meeting, because if I decide to
Yeah, okay.
I
So
just wanted to know if that'll be ready in a time frame that I can utilize that. That's all I'm asking.
no, that you'll need to consult PSC2 in order for looking at a the process for interlocutory review. So I would do that. I would not wait for the transcript if I was
Okay.
you. But the YouTube video is available because of the very quick turnaround time.
Okay.
You know, I guess it may be useful to use the video. But at this point, I would expect the transcript in 2 business days.
Okay, thank you.
All right. All right, so yeah, I'm going to remove Chris Klopp. He's gone. Okay. And do we have, that was the next thing I was going to do. Let's go off the record. Okay. Yes. So let's just back on the record. Let's state that, yeah, we've disconnected or Chris Klopp, Rob Danielson, and Peter Morris have disconnected from the Zoom connection. So just want to make sure we did that. All right. So any other issues with intervention? I don't know if I've covered everything at this point.
Your Honor.
Yes. Oh, go ahead.
Yes, I would like to ask that if there's any scientific evidence produced by anyone in this hearing, that they also include the raw data.
Okay, why don't we talk about that when we get to facilitating matters?
Okay.
So I'll ask if there's any questions about facilitating matters. So make sure you remind me about that. Okay.
Thank you.
All right, great. All right, so next up is the issues list. Now, I don't think I have quite the maybe updated conversations between parties and potential interveners on the meeting confer. So I was going to ask if Evan Whites, if you're available to chime in here just to give sort of an overview or staff perspective. Did we have any in the meeting confer, if you've been in, I know you've been involved, but can you comment on the proposed issue, if there are any, what's that stand as far as its status? Are we in
There
agreement?
did not appear to be any objections or revisions proposed to the proposed issue statement. The conversations were more about scheduling and some other issues as it relates to the hearing and evidence.
Okay, thanks. Okay, great. So then I'll accept the proposed issue as written, and basically it is our standard language, which encompasses the standards we need to apply for this case. So particularly 196, 491 for people who are non-lawyers, that's got a lot of the standards that we need to the commission needs to review when it's in processing these applications. So definitely look to that. And the other statutes as well are ones that we need to adhere to, at least procedurally. And there's some other substantive items in there as well, but I don't want to get too far into the weeds there. Otherwise, I know we had some discussion on the schedule between the parties, and I'm going to have you as well, Evan, take the lead on that too.
Sure. I think there was a counter proposal that was circulated, I guess for lack of a better term, dubbed the Jenkins proposal.
Yep.
And it seemed like from the majority of parties that should work. I note that there was one person who perhaps had a conflict with the hearing the week that was proposed. I know staff had a conflict with June 23rd that was in that proposal, so suggested the following day, which would be Tuesday, June 24th. But everyone else seemed to agree with the other aspects of that proposal.
Okay, and I know you sent me this on email, but
I think it's also filed on IRF. Attorney Jablonski, correct me if I'm wrong, but I think that was filed on IRF as well.
Judge, I have a conflict for that whole week.
okay, so I see. Thank you for that. I'm not sure who was speaking there, but so we're
Linda,
Linda.
Bryce.
Okay. So if you wouldn't mind waiting till we ask for your input. Okay.
Sorry.
That's right. So so I'm what I'm showing on the screen share is what we were calling now the Jenkins proposal. See how these things get created with a modified date for the hearing, the party hearing session. Is this is the schedule you were talking about, Attorney White? Okay, so let's set Ms. Grice aside. And were there any other comments we have about this schedule?
Your Honor, this is Jess Polakowski. We thought your proposed schedule was acceptable. We had no objection to your schedule. Likewise, though, this schedule was fine from our perspective.
Okay. Anyone else? Well, then we'll turn to Ms. Grice. Yes, go ahead.
Thank you, Your Honor. The commission's proposed schedule would work better for our schedule because I have a trial scheduled the week of 6/24.
Okay. Nasty trials always creep in there. Okay. It's around here. So I mean, if to the extent we can give people more time, this doesn't really give more time to file, does it? It just changes the hearing date. Okay. So I guess, so Attorney Jablonski, if you'd like to comment about we had the party hearing session originally set on June 17th. Which is really, I think in terms of the filing deadlines, the previous dates, those are all staying the same. So we're not giving, there's not been a contention in terms of the intervals between filings. It's just the hearing date looks like the most contentious part of this. So did you have anything you wanted to add, Attorney Jablonski, on the hearing date? Why were you recommending a later date for that?
I was recommending a later date to obviously provide more time in between when all of the evidence, pre-filed evidence, would be available and the parties would have to, conduct their cross-examination. That's what that was for. And then the other two extensions were because, frankly, everyone is busy and it's nice to have more time to brief, because these records are big.
Yeah, and I don't think the end dates are a problem, right? I think staff is okay with the brief dates. So that's good. But in terms of that week of the 24th, now maybe I'm the problem here too. I got to look at my schedule because I was going off of this latest proposal. Okay, bear with me here. Well, that week is okay. So we might be able to make everyone happy here and give a few more days to delay the hearing date, but keep it in the week of the 16th.
Your Honor, I would just note if we're talking about moving it back to that week,
Sorry, who's talking?
it's Evan White's on behalf of the PSC.
I don't see you. Oh, there you are. I'm sorry.
Okay.
Go ahead.
A witness has a conflict starting on June 18th. So if we're talking about moving the hearing back to that week, I would suggest we leave it on the 17th.
Okay, so okay.
And that's the same witness that has the conflict up until the 23rd that prompted the proposal to use the 24th on the following week.
Okay. Well, that person's just gonna have to cancel everything. Okay, so well, that puts us in a box. All right, is there any chance that that person could be substituted or have someone else present that testimony?
It's a DNR witness. I guess I would have to check. I don't want to speak for them.
Okay. All right. So, okay. So I think that, oh, and so let me hear from Linden Grice now. Sorry, I didn't want to keep you waiting that long, but go ahead.
I have the whole week of the 23rd that I cannot attend.
Okay.
I have a business where I run an art school, and it's been, people paid already for a year ago, so I can't really change that.
Okay. Well, I think on balance, what I'm hearing is we should keep that hearing date the 17th. And if there's any chance that the witness that has a conflict for the remaining days of the week can work out a substitution or some other workaround, we'll leave it at the 17th. And you know, before we get the notice of hearing out, that maybe we'll push that out a couple more days. I did want to leave at least 2 days for this hearing. So it's, you know, if we do get to push this forward, it'd most likely be the 19th, and we'd have the 19th and 20th. So in case you're, you know, planning witnesses, you'd want to have at least those 2 days available. The way we normally run the hearing is some of you'll be familiar with this, but you'll get a table that'll show the order of the parties, which is basically going to be like the table we have in the notice of pre-hearing conference. So it'll be the applicant, and then in alpha order, the interveners, and then commission staff will be last. So the order, we can make adjustments if there's good cause. It's up to the once you have the order of parties, the order of your witnesses, each party's witness is up to the party. But in terms of the order of parties, we usually go through that standard. We can make exceptions though. And so that's just generally if you kind of gauge if we're starting on the 19th, you know, you can try to see how long, where your witness may fall in the process. Staff would probably be on that second day if we need the second day. I think so. Our last wind farm case was in 2013, the Highland Wind Farm, and I think that was like a 4-day hearing maybe. And then we had multiple hearings, so with different reopeners and things, but that hopefully won't be the case here. So, so let's keep the 17th of June. With the prospect that possibly we can push it a few days out to the future of the week of June 16th. Does that sound good for everybody? All right. So I think, and in terms of the schedule, I don't have a problem giving more time for the briefs if staff's agreeable to that in terms of the back end timing that they have to deal with. That's fine with me. So we'll just, so in terms of the schedule, I'll approve what you're seeing on the screen. Although maybe this actually is no. Yeah, okay, so we'll do the initial schedule. No, that's not true. You know, initial schedule it is the initial schedule. Okay, we're back to the initial schedule, basically is where we're at. Okay, well, that was easy. It just took a while.
Your Honor, just a point of clarification. So are you approving the initial schedule with the modified briefing deadlines? Is that what we're working with?
Well, the initial schedule has those briefing deadlines. That's what oh, the initial proposal? Yes. The
Jenkins proposal had later brief deadlines.
Oh, the 8, I see. Okay, I'm mixing that up. Sorry. Yes, the proposed schedule with the Jenkins brief deadlines. That's what I'm approving.
Okay.
Your Honor, just so I'm clear then, the initial brief will be due July 18th and the reply brief will be due August 1st?
That's correct. Okay. All right, so now facilitating matters. This is where we get really into the meat of the hearing here. So in the notice of pre-hearing conference, I provided a copy of our standard facilitating matters order. So all the details you need to follow when you're filing documents and filing documents as a party and participating at the party hearing session. So this is not in effect at the moment, but I will put it into effect when, well, let's say we can discuss making some changes here and they'll go into effect after the pre-hearing conference. You will get another copy of this in what I call a pre-hearing conference memo, and that'll be reflecting the decisions we're making today, as well as another copy of this facilitating matters document. If we have any changes to that, it'll be in the body of the order. You'll see it before you see this document. And then, but this is the standard language that we usually applies once we order it in each case. So it's pretty detailed. I'm open to hearing questions, any modifications that people want to propose, or just any clarifications. And I know, Linden Grice, you had a question, and I said I would remember to ask you about that. So why don't we start with you? And unmute. I think I can unmute you.
Yes, I would like to see us have all of the raw data for any kind of scientific experiments that are presented. I'd also like to see who paid for that research.
Okay, so can you just be a little more specific by what you mean by raw data?
The raw data is the actual data that's presented that is the information is derived from. It's not like average or something like that. It's actually what they got in the experiment.
Okay. The inputs to a study or a...
Yes.
Okay, so I guess I'm not adverse to that. I think we may just need to be a little more careful about how we word that in order to make sure we all know what rules to follow. So one thing we need to think about is there's parties will typically file as exhibits documents that are already in the public domain, and some of them could be like scientific studies, hopefully peer reviewed, and something that we can rely on. And that's something that we may need to get into during the hearing, whether I can accept the document or not, whether I believe I can trust its reliability. So if it's a peer-reviewed article from a published scientific study, we usually, and then the witness can use that as the basis of their statement, their testimony. Say, I reviewed this study and based on that, looking at this project and using this study, I think that the project is X. So in that situation, I don't know if we can reasonably ask the filer of that document to provide like the background data. I mean, obviously and so I just wanted to make that distinction where if you're talking about someone does a ground study of, I'm assuming sound may be the big one, that the scientist, the person offering that study would provide to the parties the background data, the back end inputs to that study. that sounds reasonable to me. Do we have any comments from anyone about that? We can start with the applicant.
Thank you, Your Honor. I guess I, as a general matter, have no objection to, on a case-by-case basis, agreeing to provide all of the data. I think for the most part, we actually provide the underlying data with the reports. I just, as a generalized matter, I'm concerned that this is going to be a gotcha. I don't know what in particular we're looking for. So I would suggest that we just handle it on a case-by-case basis. To the extent that there is data that hasn't been provided that one of the interveners would like to see, we will certainly cooperate and get the data out to them.
Okay. Yeah, I'm just concerned about the timing because it's very quick deadlines here in terms of turning around testimony. So that, I mean, what we normally do, and this is for Linda, this is kind of for your benefit, but what would normally happen is that if a witness is presenting a study, they're offering the study, they may offer the background data just as par for the course, but it's not really required. But if you wanted more information on that, you could then request and ask the applicant to provide that. And we call that a discovery request, to say, hey, you mentioned you looked at 3 sites for your sound study, and can you give me all of the raw data for all 3 sites? And then they would hopefully comply quickly with that. And so there is that delay and that process. Now, when you have attorneys and big law firms, and it's just part of practice. It's just normal run-of-the-mill stuff. But for landowners, individuals working pro se, that could be very burdensome. So I guess to the extent that I can ask the applicants to provide the raw data, to the extent it's not in the filing to begin with, that would just quicken the process and prevent that kind of delay or burden on non-represented parties. There's always the discovery process to back that up if, for whatever reason, the recipient doesn't feel like they've gotten all what they thought they should. But yeah, I think if we can narrow it down and say for scientific studies originally produced by a sponsored witness in the case, that along with the study, the raw data be supplied to the parties and commission staff as a discovery response, to the extent it's not already in the filed document that's being offered for the record. So I'll just note that in the facilitating matters order as additional requirement. Okay.
Judge,
Yeah, go ahead.
Can we also ask for who funded the research?
The funding. That's a fair question. That's another thing that gets typically asked by attorneys, vetting witnesses. I can allow that to be just stated in a discovery response as well. Just make that a standard response. Who funded the study? Any response there from the applicant?
No, Your Honor. I think we try to be as transparent as we can in our submissions. There was an issue raised that I just want to address with regard to the formatting of documents.
Okay, yeah. So let me just check back with Linda Grice. So is that covering what you're interested in terms of?
Yes, very much. Thank you, Judge.
Great. Okay. All right. Yeah. Go ahead, Jessica Hudson.
Sure. Thank you, Your Honor. I'm not sure who raised the concern, and it may have been Ms. Clapp, who is obviously no longer an intervener, but to the extent that there is information that's been uploaded to the IRF system that an intervener would like us to provide in a different format, we'll certainly accommodate that request on a case-by-case basis if we're able to do so. Sometimes these are very, very large documents that can only be produced in certain formats. But I can't agree to provide everything in a certain format because I don't think it's technically possible to do so.
Okay, that's fine. Thanks for providing the information to everyone. I think that's useful for people to know right away. Any questions about that?
I have a little bit different question.
Okay, go ahead.
This is Gina. Regarding the discovery with this short time frame that we have, you mentioned something that we may not get an answer to our question. What is our recourse then if we have a question and we don't get a response?
Okay, so that's a great question. So there is a process by which parties can request information and then complain to me about the lack of a response. So it never comes up quickly when you want it to. Yeah, so it's in here, the hearing prep section. Here we go. So pre-hearing procedures, discovery. So this is something that attorneys do very frequently. And so what we've done here, there's certain statutes that govern the process and apply to administrative hearings. And this standard, these procedures are done to slightly modify those requirements in order to match our practice, which has these very quick turnaround times, relatively speaking, compared to a court. So there is, and I don't, hopefully we don't have to go through all the details here, but the important part is that if you're not getting an answer that you thought you would get, you need to first, you should be consulting with the applicant or the person you're seeking the information from. If that doesn't get you anywhere, you should be filing a request to me, and I need to decide whether that information should be produced or it's okay for them not to produce it. So that's you'll see that reference to a request to compel a response to a discovery request or data request under Section C. Section C is down below, and it talks about filing a request to me. So and then there's an opportunity to respond, and I'll have to decide and issue an order, or we'll hold a brief hearing on it, and I'll make a ruling. So we've tried to shorten what's currently in effect in civil procedure, so that when you ask for information before rebuttal is filed, the response should come to you within 21 days of when you gave that request to the person you're seeking information from. But they're also supposed to tell you, where is that? They're supposed to tell you in 5 days whether they're going to give you that information in full or not. So if they're going to object, they should be giving you advance warning of that. And then you can say, well, if I really need this information, I'm going to ask the ALJ. It's different if they don't object, but you don't feel like they've given you what you were looking for. You're going to have to wait until the deadline for them to file it with you. But if they're going to object and say, we're not going to give you everything you asked for, there's an opportunity to kind of push faster and get that request out to me sooner. It's not ideal. And because there's paperwork involved and there's decisions to be made, it takes these kinds of practices, this process takes a lot longer than is useful in many situations. But it's the best process we've had come up with so far, and it works most of the time. And I know that applicants do their best to provide a response, and there could be arguments about that, but for the most part, it's been working pretty well. So I'm not too amenable to doing any radical changes here, but let's see how this process works in this case. And the ultimate relief you can do is ask me to help get this information by filing a request to compel the information. So that's always an opportunity that you can make.
Okay, thank you.
Yeah. All right. Any other questions about the facilitating matters? Oh, Eric, yeah, you got your hand raised.
Thank you, Your Honor. Just for the purposes of the record, are these days business days for the 5-day and 3-day timelines?
5-day, anything, anything under 10 and what is it? 11, yeah, 10 days and under are business days. Yeah, that's how you should read it.
I think it's 11, Your Honor, according to the statutes on
Oh, yeah, you're
counting
right.
time. An odd number. It would make more sense to be 10, but it's 11.
Well, it's, yeah, inclusive of the, yeah. Okay, Mary J. Owen. So Mary Jo Owen, sorry. Oh, what did I do there? Lowered your hand. You need to unmute. Mary Jo, did you have a question?
Yeah, I guess I was trying to say something about the timing and the conflicts. I mean, if you make changes to the schedule Monday through Wednesday, I have conflicts. But if you do something on a Thursday or Friday, I won't unless you give me enough notice that I can rearrange my clinic and OR schedule.
Okay, I'm sorry. Let's just
But
go.
you've had me muted. Well, you asked for conflicts and I was trying to give them to you, but I was muted and I wasn't able to speak or unmute myself.
Okay, so just
So
back
Monday,
up.
Tuesday, and Wednesday, I am tied up
So
unless
what-
I get enough notice to my clinic and OR.
Yeah, so let me.
But Thursdays and Fridays, I can accommodate whatever you guys do.
Can you hear me? Can you hear me? Mary Jo.
Yes, now.
Okay. What week are we talking about? You're talking about this week of June?
Anytime you need me to be present in person or on a Zoom uninterrupted, it needs to be on a Thursday or a Friday for my schedule, unless you give me enough notice
Okay.
that I can rearrange the OR or the clinic. Is what I was trying to say, but I couldn't figure out how to unmute, so I finally figured out how to raise my hand.
So June 17th is the hearing date. You've just been given
And
notice.
it's what day of the week is that?
Tuesday.
Tuesday. Okay,
Now,
it would.
You will know at least 30 days in advance. We will send
It needs to be. I'm supposed to give
I
it
need
to my
to-
clinic.
I'm sorry,
6
ma'am.
months.
I'm
in
sorry,
advance.
ma'am. I'm talking. Now, I know people who aren't used to these processes need to learn quickly. And I hate to do this, but we can't talk over each other. I understand your situation, but let me explain. I've set the hearing date for June 17th. There's a possibility that we may push that forward a few days, possibly the 18th and 19th, to accommodate other people's concerns. You will
Is
know
that forward or backward?
Okay, I'm going to mute you, and I'm just going to say what I need to say. Okay. June 17th is the hearing date. We discussed before is that if a witness that has a conflict for that week can cure that conflict, I can provide a few more days for before the hearing to accommodate what some people's concerns, some parties' concerns. Therefore, the hearing may be on the 18th and 19th. But as far as I know at this time, I'm setting it on the 17th and it may run into the 18th. So you have notice. If you need to do something with your schedule, do it. But what I can say is that we must give notice of the hearing at least 30 days in advance of the hearing date. So you will know for sure what date it is when the notice of hearing goes out. That's the official announcement of the hearing date. So if something changes, it'll be changing before mid-May. And it will be the change, most likely would be, it's right now the 17th of June. It might change to the 19th of June. And that may give you issues with your schedule, but I'm giving you as much notice as I possibly can. So I hope that helps your situation, and I hope this explains your concern. Okay, so let's now go into other facilitating matters. Anyone else have a question? So I wanted to mention a couple of things. There are a few pitfalls that people find themselves with all these hearing requirements, filing requirements. One thing I can mention is what I've tried to do is something, again, people who've practiced before us will probably be familiar with, but others, it's totally foreign. It's this party identifier. You'll see that on the notice of hearing, notice of pre-hearing conference. So this is what I'm saying. This is something you'll use, or you should be using for your written filings as part of your page numbers and your IRF document descriptions. So you'll see what I mean by that if you review the document. I'm just going to scroll down quickly to show you how this works. So this is a table that gives you what the name of your testimony should look like. And so we have the round of direct testimony, then your party identifier, the witness name, and then when you go into the document, each page should get a page number. So that's what I mean by the party identifiers. The reason why we have all these requirements is that the commission is reviewing multiple cases at the same time, and they've been doing it this way for many years using this format. And to deviate from that is going to be extremely burdensome for the commissioners to have to digest all the information in all these different cases. To see them in different ways at different times is going to be very difficult. So we've created these standards so that they can quickly and cleanly understand where they're at in a document, who's speaking, what round of testimony you're in, and how, and doing that across the board in all cases makes it much easier and makes their participation, their review of the record much more effective. So it's everyone's benefit to comply with these requirements. And I'll say that the consequence of not complying is I'm going to make you refile. It's a extremely burdensome part of my job, as you will see when we get to this point. But so do your best to apply these standards. You can always contact the case attorney for questions, initial questions. If there's something they can't answer, they'll ask me to clarify, dig into it deeper. But in terms of the procedural questions, please contact Evan. And I think who else was on this case? Was it
Stephanie Bedford, Your Honor.
Oh, there you go. Thanks. So they'll try to help you with that. And there's also, if you look on IRF, on our IRF system, you'll see examples of the documents. Now, not everyone files these correctly, so please try to look for the revised versions of these documents. You'll see the better versions of them if you look at the revised ones and try to use those as models. And I can just do a little, I'm going to go off the record for this. Sorry, Debbie. But let's just show you briefly if you're on IRF. So this is a case where most filings came in very correct, in the correct formats. And I can just show you. So, for example, this one is direct Maple Grove Solar, and the witness name, it's revised, has an R at the bottom. Their testimony presents itself correctly in terms of format. There's question and answer is how you present your witness as if they're on the witness stand, and lines are numbered, and there's your page number for the page with the additional 1 because it's page number 1. And it just goes through all of that. That's your basic testimony format. Your exhibits look a little different. Let's find a good one. So here we have a exhibit from Renew, and you'll see instructions on how to do this. You need a cover page. You need the name of the document at the bottom, and then your document's just presented as the rest of the pages. And you don't want to add anything to this document. Keep it as original as you have it, as original as you can provide it. If you made marks on this before and this is your only copy, that's what you have to file. Well, we can deal with that later, but don't add a page number to this. Don't add your name or your party number to this. Just want the document as you have it in original form. You'll see that we stamp all of our documents. You want to leave room for that so we don't have things over-typed. And the reason for the cover page is that a lot of times, if you just file the document as an exhibit, you'll have interference with this PSC reference number won't be visible. So that's why we do cover pages. The other important thing is this little disclaimer. We used to do the much more burdensome way of doing this was to have people remove all citations, all hyperlinks from documents. We're not doing that anymore. You just need to disclaim that the information contained in this citation is not exactly what you're supposed to do, but basically it's saying that the citations themselves aren't record evidence in this case. You're not offering them for the record. You're offering this document, but not all the things that it's referencing to. We're not going out into infinity and looking on the internet and going into everything that this is citing. That's not being offered for the record. Commission will only look at these pages to use as the basis of its decision. It won't go further from this document. So that disclaimer is letting everyone know and reminding everyone not to do that, not to click any links, not to go further than what's being offered in the actual document. So you'll see these kinds of disclaimers, and the language to how to do that is in the facilitating matters order. In testimony, there's another, I don't think I can find that here, but you also want, if you're making citations to documents in testimony, you also want to add a disclaimer to those. And I'm not going to make you wait for me to find one of those, but applicant usually files first, so you'll see their version. Hopefully the formatting will be correct, and you'll be able to use their document to base your formatting. What I'm going to try to do is get you corrections earlier than the next round of testimony, at least in the direct, so that you can see what you did wrong and then how you can avoid doing those mistakes in the rebuttal. But I'm not going to make you refile until after the hearing. So when I say there's these corrections you're going to need to make, refile after the hearing. As long as we know what the mistakes are while we go into the hearing, and we're okay. But we want to wait to file the final version till after the hearing in case we're making other changes or, something else is happening. But, a lot of times people will come to the stand, get on the stand and say, oh yeah, I forgot, I need to make this other change. This just avoids you having to file more than once, having to refile more than once. And the way to let people know you have a mistake is to file what we call an errata, which is a different kind of document, and I can show you a format of that too. Yeah, for this case. Well, it's case. Well, maybe I'll get you some examples when we get closer to the time to do that. But errata just gives everyone just a heads up. Certain you have an error in a line in testimony. You meant to say and, but you used the word an instead of and. You can just say and should read an, and then it's very simple, just pointing out the problem, kind of like a proofreader's errata. So that's explained in the facilitating matters. And so those are kind of the major things that pop up when we need people have questions about, people get when they misfile things. That's the main bulk of those things. So otherwise, please review that document, this facilitating matters document, and if you have questions, contact the commission about it. Anything else?
Your Honor, this is Evan Whites from the commission. Did we address whether or not the hearing will be virtual or in person? I think that was one other remaining.
Right, thanks. Yeah, let's get on the record. So we should clarify whether we'll be meeting together. We would do that in Madison in the commission hearing room, or if we can hold the party session as a Zoom only proceeding. We also do a public hearing session in the project area. We'll do that in person. We'll do that on location. But in terms of the party session, we have the option of going either having people in the room and the opportunity for some people to connect in Zoom if they need to, or doing everyone on Zoom. Anyone have a preference either way? Kind of agnostic. If we're doing it Thursday, we have some advance notice. We may have to jigger some schedules around at the commission, but that shouldn't be a problem. But any opinions either way?
This is Eric Olson for WPM, Your Honor. We would prefer to do it in person.
Okay.
Our preference, Your Honor, would be to do it virtually, just because we will have witnesses from out of town. Although if there's a strong preference that it be in person, we will undertake to have them in Madison.
Okay.
This is Gina. It's very difficult on a Zoom to really read everything that's going on. My preference would be in person.
Okay, so just can you clarify for me what do you mean by reading everything?
In my screen that I have right now, I don't see all the people. And so when someone starts talking, it doesn't automatically come up. So you don't see what's happening in the exact moment.
Okay, that's good to know. All right, I think George, you had.
Yes, in person, Your Honor.
Okay. Mary Jo? I have to unmute you. Hang on.
In person, Your Honor.
Go ahead, Mary Jo.
In person, Your Honor, would be my preference.
Okay. Attorney Jablonski?
Same thing, Your Honor. Would also prefer in person. Thank you.
Yeah. All right. Well, I think I've heard enough that, and it looks like just from the number of people, the sheer number of parties, in person will be beneficial to our efficient administration of the party session. So I'll lean towards that. I'll see if I can get the room opened up, and we'll see that in the notice. In the notice will be the definitive statement of where and when the hearing will be, but I would say plan for in person. Let's not say in person. Let's say on location at the PSC building in our.
And, Your Honor, I know, and just so everyone is aware, it might be helpful to clarify what those days will look like in terms of a timing perspective. I know sometimes we can run late.
Okay, so we can go off the record for that. I don't know if we're on anymore, but yeah. So I'm hoping not to go too late. I've made a commitment. not to go too late, as we have done in the past. Some hearings we've spent maybe 8 hours straight with very little breaks, just slogging through a case to get it done in one day. And I think our record has sorry, there's someone hearing somebody else here. I'm gonna mute Mary Jo again. Okay. So I was saying, so 8 hours, maybe more, 10-hour hearings in one day. None of us are at our best at that point. So I think we will endeavor to shorten things up, and because I can't give so it gets kind of tricky when you have a witness on the stand, and the questions seem to take longer than you anticipate. There's nothing really we can do about that, and it makes sense a lot of times to finish a witness, not to cut them off, bring them back the next day. But I would say let's endeavor to end the hearing at 6 and start up again the next day. I'm hoping we can do this in 2 days. That's the plan. But if whatever time we don't need, I can give back to you. Let's say, and like I mentioned, we'll stick with the order of parties that's in the table that you saw in the notice of pre-hearing conference. So the first day we would expect applicant witnesses, and if we can get to others on that day, that all the better. Hopefully that'll be the case. And we'll take it from there. So I don't know if I answered, kind of touched on everything you were thinking about there, Attorney Polankowski, but.
That was helpful. Also, I just wanted to flag for Your Honor, I don't think it is an issue for the commission, but if we do push the hearing date back, we're bumping up against Juneteenth, which not an issue from my perspective. I just wanted you to be aware of it in case that does raise an issue from the commission's perspective.
Okay, so let's see, we're going to be, not the 20th, or is that?
That would be the 19th.
19th, okay, yeah. Well, yeah, I don't know if I can accommodate everyone's perspective there. I guess it's not an official holiday, and typically that's where when the building is closed, when employees are not working, that's when we're not holding hearings. Otherwise, I think it's usually fair game to hold a hearing on days like Good Friday, etc. So, but I appreciate you bringing that to my attention. Okay. So I don't have anything else pressing to keep you here for. Anything else I can help with? Other questions, concerns? Okay, so look forward to getting the pre-hearing conference memo in the near future. In the meantime, let's just use what we've determined here today as the process going forward. The memo just reflects what we've said here today, shouldn't deviate from what we've done here today. So it may take some time for that order to come out, for that memo to come out. So just if you refer back to the video or the transcript, you can do that until you get the order. All right, thanks everybody. Appreciate your attendance and your participation, especially your patience with all of the technology and all the different issues we've had to bring up here. Hopefully, as we go through the process, you'll become more familiar with all of the ins and outs of this, and process will be much more clear to you by the time we get to the hearing. But otherwise, thanks very much, and we'll adjourn. Take care.
Thank you.
Your Honor.
Stan.
Yeah.